Thank you. Good
It's
morning.
recording.
Today is Wednesday, January the 8th, 2025. My name's Roxana Gamusio. I am the Executive Director with the Collection Service Board, and this is our regularly scheduled meeting. It is 9:30, so as first order of business, I will go ahead and do roll call vote to make sure that we do have quorum. Members, thank you for being here. When I read your name, please let me know that you are here for the record. Chip Hellman.
Present.
Thank you. Greg Zworski.
Present.
Thank you. And Tony Zukovich.
Present.
Thank you. We have Lori and Jason out today, but we do have quorum in order to proceed. Notice of this meeting was posted to the website since July of 2024. The date, time, including the location, has been available, and then this current agenda was posted on January 2nd of 2025. Any members of the public here in person or participating through our Teams link will be able to provide comments at the end of the meeting. We will make sure through Dana, if they've raised their hands and they have any questions regarding the agenda or items covered, we may need to limit the speakers to 3 minutes, but we will do that under new order of business. So the first item that we'd like to do is, members, if you can review the agenda, it was emailed to you prior as well. And if you have no changes, I would need a motion and a second to accept it.
Second.
Thank you. We have a motion by Chip and a second by Tony to accept the agenda as presented. All those in favor, please say aye.
Aye.
Thank you. Next, you have on your iPads, and this too was emailed, the October minutes. That is the first item right after the agenda. If you have any changes, please let me know. Otherwise, we would need a motion and a second to accept the October minutes. Thank you. We have no changes to the October meeting. We have a motion by Greg and a second by Chip. All those in favor, please say aye.
Aye.
Hearing none opposed, the minutes are accepted. Thank you, members. First order of business, this is our first meeting for 2025, so we will need to motion the fact that we proceed our meetings and conduct ourselves following Robert's Rules of Order. If you have any questions on how that is handled, we have our wonderful attorney, Joe, here with us to be able to explain that. This is something we do each year at our first meeting.
I move we adopt the Robert's Rules of Order for our meeting.
Thank you.
I second.
Thank you. We have a motion by our chair, Chip Hellman, to adopt and follow Robert's Rules of Order for our meetings, and a second by Tony. All those in favor, please say aye.
Aye.
Thank you. Any opposed? Hearing none. We will proceed with our election of officers, and that too is done the first meeting of the year. This would be we would update the website with these names and carry this out through all of our meetings in 2025. So we need to motion and elect a chair, a vice chair, and then also a secretary. Do we have any nominees or suggestions for one or all three, however you prefer?
As I said,
Go ahead and
for a question.
yes, and if you can turn your mic on red, so, thank you.
Is
You're
that
good
it?
now. That's
Yeah,
it.
good. As I said, I'm looking at retirement. I do have ownership in my company. I don't know if that would qualify me to stay on the board. I guess that's my question. It's a good one, isn't it?
I don't think your ownership interest in a licensee is going to affect your board status. It wouldn't continue it as opposed to you just staying on the board. So essentially, if you want to stay on the board for the remainder of your term, whenever you retire, you would just time out at that point in time.
Great, thank you.
We are.
Go ahead and turn your mic on. Thank
Oh,
you.
that was on. Okay. Darn. Is this board supposed to have a certain number of industry people as well as non-industry people, right? So I guess I want to clarify the mix. I want Greg to stay on. I'm in the industry, but just to be clear, I have ownership in a collection company as well, so that puts me in the industry, I suppose. But, and then do we have adequate representation from outside the industry? Tony?
Lori, yes, and
Is-
Tony.
Is that all we need, is one?
The way that the statute reads, it says at least 2, but no more than 3 of the members shall be engaged in the collection service industry. So as long as we have 2 people engaged in the industry,
Okay.
we are good to go.
That was my question. So I think we are good to go.
Yes, yes, I think we are good. And so any of the positions that you wish to vote on would work. I think right now, Chip, you are our chair, Greg, you're our vice chair as it stands, and then Tony, you are our secretary. If we have a motion to change those, I welcome those, or to keep them as they are.
I'm fine with keeping them the same. But I don't want to make that motion.
No. We need to make a motion.
Yes,
Tony made it, I think, and I'll second.
I'll make a motion to keep the positions the same.
And I second that.
thank you. We have a motion on the record by Tony and then a second by Greg, and the motion is to keep the positions as we have them, which would mean Chip Hellman is our chair, Mr. Zaworski is our vice chair, and Mr. Zikovich is our secretary. And so all those in favor, please say aye.
Aye.
Thank you. That takes care of that annual order of business. Next, members, on the iPad is the budget for kind of an update on our numbers, and I'm going to get you the page number here in a second. Thank you. On page 22 on your iPads, that's an updated version of our financials. It is through November 2022. This reflects an additional deficit of $59,106. It leaves our reserves at $760,316. You know, we've addressed the trends. I think this is continuing in that pattern. I don't see any changes coming up. Any questions that you have, I welcome, but otherwise, our reserves are still substantial enough that the program, you know, at least for now, doesn't foresee a fee increase or anything like that. Good? Okay.
Yeah, it looks fine to me.
Thank you. Okay, so the next item under our, the director's report is a conversation that we want to have. This starts on page 23 of your iPads. I have a copy of a current process and what we're recommending as a revised, as well as kind of a graph to discuss ownership in companies. Basically, in 2019, and you've got on your iPads also the minutes from the May meeting of 2019. Chip, you would have been on the board and might remember this. We had the conversation regarding change of ownership and at what level the change of ownership should really require a new application, especially when we're talking about the direct ownership or the different layers where it's an indirect ownership and the change is actually at that second or third indirect level of ownership. And as it stands right now, based on the May recommendation, now this isn't a law or rule change, we're following what the laws and rules require. This is more within our structure and interpretation to do the licensing. We've been requiring a change of ownership if there's a change at any level of the ownership. And so that is actually more demanding than what we require for our, you know, initial application from our owners. So we would like to proceed with making a change to where if there's a direct change in ownership, then they are applying for a new application and the change of ownership, but only when it's direct and not at, you know, further down. Welcome any questions. Joe can also elaborate. This is something obviously with Bob as well. We've discussed because we have companies that, you know, it's a lengthy process for them to change that ownership when in fact there's no change in their minds.
So it would take 50% or more to change, is that right?
Go ahead.
Well, essentially what we're looking at, the 50% or more is codified in our rule, and that's one of the rules that we're going to be adjusting today in our rule-making package, just defining when that change of ownership happens. Today, for this conversation purpose, what page is the graph on? On 24, I put together like a little very simplistic chart and then also included the statute. The relevant statute is 6220-108, and it reads, "The board shall be promptly notified in writing of any change in address, management, or ownership of a collection service business." So the key here, and I believe it was part of the analysis of the board back in 2019, was the word any. Okay, so we have any change. Now, I would state that it is up to the board's interpretation. But if we also look at the word any and then of a collection service business. So something for the board to consider, on this issue is, does the change in ownership of, let's say, LLCB, that's in red, if there is a change as far as that LLC is concerned, is that really a change in ownership of the licensee? Or is it a change in ownership of just that LLC within itself? So again, your interpretation, this is your ballpark, but essentially I would say instead, in considering this issue, we could either focus on the word any, which would be the wide scope, or then we could focus on the licensee itself and whether or not any change down the road in chain of ownership of LLCs and corporations is actually effectuating a change in the direct licensee, if that makes sense. I mean, it's two ways to look at the same issue, if you will.
Okay. What are we interested in here? Are we interested, I'm trying to think of the motive behind this. Are we interested in identifying change or being notified when there's a change of control
I would say-
versus just changes to the ownership stack, if you will?
I would say there's a level of consumer protection. We want to make sure that, someone that, quote unquote is a bad actor, if they become an ownership of a licensee, does that affect the licensee's credentials, health, and their ability to protect the public? And then the other point of it would be in our initial application, we ask for a potential licensee to enumerate direct ownership. So we evaluate direct ownership as a program in order to issue a license. However, with the board's previous interpretation in May of 2019, once you're licensed and we only consider direct ownership in order to grant you a license, if there's a change in indirect ownership, even with a company that's not directly involved with the licensee, you are then, based off of the board's prior interpretation of the statute, supposed to turn over more information to the board after you're a licensee than you needed to originally get licensed. So it essentially casts a wider net and more due diligence on the program once you've entered the ballpark as a licensee and you're legally practicing in Tennessee than you had to disclose originally. So the consideration is, do we really need our licensees providing additional indirect ownership information when we have already licensed them? Because essentially it's more work for the board, it's more work for our licensees and all of that.
Yeah, does anyone remember why we took that position in 2019? Or did it just sail by us?
I think, and the minutes are there, but they capture just a quick recap. I think at that point, maybe we didn't explain it as well or dive into the interpretation that you're actually asking for more information down the road than you originally needed. And maybe it wasn't as relevant, right? The different tiers of ownership actually selling and changing as it is now.
Okay.
And so I think the reason probably was thinking that you were protecting the public by doing this, but the domino effect as more and more companies are changing hands and is become burdensome to our
Yeah.
applicants.
It does not
our license.
seem logical to me that we would require more from an existing licensee than we would.
If
And
I
it-
could add something to this that might help in the consideration too, because I get to process all of them. Typically, if there is a change in, that example, we're looking at LLC 1 or 2, the direct ownership, they will submit items for the new ownership, and there will be different items. If the change of ownership goes beyond that into example here for individual A or LLC B, I'm getting an application across that has everything that we already have in the file. There is nothing changed, and all we're doing is charging them the fee to process a new application for nothing being changed on it.
Right. We have to fix that,
That's why we're.
right? So what are the steps? Do we I'm not sure I can craft a motion that would,
It essentially would be the board providing the program direction, and essentially how you want the staff that represents your board to basically process this information and then seek it from licensees. And my understanding, and probably the way that Bob would, move forward is, anytime he receives information regarding a change in direct ownership, contacting a licensee and saying, hey, we appreciate you sending this information to us. We know we've had you send it in before, but we're no longer going to be looking at this information. We're just concerned with direct ownership change.
and what is the threshold for direct ownership change? Is it a change in control, or do you want to know, are we wanting to know all the minority, because shareholders can change, right? It seems to me the concern we have is who's controlling and running the business, right? And because they're the ones that can affect whether a consumer is abused. A minority shareholder can't really, they can impact it, influence it, but at the end of the day, the controlling entity runs the business.
With the way that we have the rules set up to change in our interpretation of the rules that we have amended, it is a focus on change. So for example, in an LLC or corporation, the rule that we will discuss and the board will examine later would say a change of 50% or more of the ownership interest of the LLC has changed. So
Okay.
even though we're not defining it as ownership, having 50 or 51%, you are the controlling actor within that LLC or corporation.
Okay. So you need direction from us. And does that need to be in the form of a motion?
Yes, it would be.
Okay, so I'm going to take a run at it.
Please.
I would make a motion that our requirements for existing changes to existing licensees not exceed our requirements for new licensees.
Perfect.
That's great.
Okay, that's the motion.
I would second that.
Perfect.
Good job,
We have
Chip.
a motion by our chair, Chip Hellman, and a second by Greg Zaworski to basically not ask for additional information of our existing licensees due to a change of ownership and limit it just to that direct ownership piece, correct?
That
Thank
is
you.
it. So we need a vote, right?
All those in favor, please say aye.
Aye.
Any opposed? Hearing none. Thank you, members. That really does, I think it falls in line with what we should be doing and a good interpretation. So I appreciate that immensely.
That crazy board back in
I know.
2019.
What were you
that-
thinking?
Yeah, probably.
Sorry. I will turn the meeting over to our wonderful attorney, Joe Wardham, and your current complaints start on page 27 of your iPads. Those two were emailed to everyone, and so I will let Joe go into the cases. Thank you.
Good morning, board members. There are 22 total complaints on the legal report for this board meeting. 21 of them are first-time presentations. Complaint number 22 is a representation from our meeting in September. I'll give you a chance to read over that and ask me any questions that you may have. And then, obviously, if the board would like to make a recommendation or change of decision based off of what I've written down in the legal report, we can discuss. And then, obviously, I'll notate that and move forward and make that change.
Does anybody have, well, we have plenty of time, so if you want, we can go longer, or if you have questions, feel free to speak up.
I think I'm good.
I am too. I don't think we have any questions.
Okay. I think we should do this a little different than we normally do, and I'll explain why. I'm going to go ahead and read the complaint numbers into the record since you guys have evaluated the complaints. The first 21 complaints, as I previously mentioned, are first-time presentations. You all, as a board, can go ahead and then vote on those 21. Due to the licensee and a conflict of interest with complaint number 22, which is being represented from the September legal report, I believe we need to pull that one out of the total stack, and Chip, you and Tony can then basically vote on what you believe the recommendation for complaint 22, just for recusing purposes.
I'm going to recuse myself from
Essentially.
Okay.
Okay. All right. So I'll go ahead and read all the complaints in the record. Then we'll take a vote on the first 21, and then we will take a vote on complaint number 22. Complaint 202-404-9631. Complaint 202-405-4841. Complaint 202-405-5161. Complaint 202-405-2511. Complaint 202-405-2731. Complaint 202-405-4281. Complaint 202-405-2501. Complaint 202-405-3161. Complaint 202-405-4071. Complaint 202-405-4321. Complaint 202-405-5321. Complaint 202-405-6201. Complaint 202-405-6341. Complaint 202-405-7671. Complaint 202-406-0301. Complaint 202-406-0321. Complaint 202-405-7871. Complaint 202-405-8151. Two zero two 405-9281. Complaint 202-406-0201. Complaint 202-406-1761.
Members, if you're good with the first 21 cases read on the record, if we could get a vote to follow the recommendations that Joe has presented, or if you have any questions, we can still obviously address those now.
I don't have any. Move to accept items 1 through 21.
I second.
Thank you. We have a motion by Chip and a second by Tony to accept cases 1 through 21 as read on the record. Following Joe's recommendation, all those in favor, please say aye.
Aye.
Thank you. And Joe, number 22, please.
Complaint 202-404-2501.
So I want to discuss this one, if you don't mind. So the original recommendation was to issue a consent order with a $500 civil penalty, which we did.
Correct.
Right, and approved by the board. And then the attorney for the respondent contacted you and we talked through this.
Correct.
And you were satisfied at that point. It's your recommendation that we, instead of doing the consent order, we just do the letter of warning.
So in full disclosure, I obviously made the attorney aware that I cannot speak for the board. So
Right.
essentially, this would be framed as an update in fact. So after they received the consent order, they basically said like, hey, we've looked through the file. We understand, that there was a mishap here. You've asked for a $500 civil penalty as part of your consent order. However, we went ahead and looked at the file. The debt is $742.06. That's more than your consent order amount. What if we went ahead and took care of that balance, so zeroed it out? That way the consumer no longer had this heartache or this issue to deal with. And then you could update the board as to that fact, and it could be just another element of the total story, and then the board could reevaluate it. And they asked as part of that negotiation that if, I proposed to the board, if they did that, changing it from a consent order still till a letter of warning. So essentially, they understand like, hey, we may need instruction in this area, X, Y, Z, but, updated the facts to it, and I told them I would represent it to you all based on that fact.
Okay. So when I read through the original, collection agencies, being in the industry, almost daily we're faced with what is the worst of, I don't know really how to say, you're damned if you do, you're damned if you don't. If you place the account in a cease communication status, you're operating with an abundance of caution to protect the consumer, which is really good. On the other hand, if you get your hand slapped because you didn't validate the debt, in other words, man, that sounds great. So there are many situations almost daily, particularly in a larger collection agency, where you're damned if you do and you're damned if you don't. And management has to decide ultimately, what is best for the consumer?
And I believe you hit the nail on the head, and I considered that a material fact in my original summary. It wasn't
Okay.
like, hey, we just didn't validate the debt. Hey, this documentation wasn't issued because we had put this consumer file in a ceased communication status, which to me is a reasonable explanation, and I can understand how, such a mishap could happen, even though we still got to get the validation documentation out. So
Right.
that's why I included it in the original summary. I agree with you. I do believe that is a fact that should be considered within
So-
the total scope.
So then we continue on, we bring it to the agency's attention, and they don't just pay the $500 fine and move on. They say, honestly, I love it. Better use of funds is to take care of this debt. So the provider gets their, if it's a healthcare account, the original creditor gets their money. The consumer is better served, because if we just pay the $500 fine, the consumer still owes the money and we're going after.
$742.06. It would still be bearing down on their current credit situation and credit report.
So it feels to me, and I'm biased because I'm in the industry, but it feels to me like the agency went over and above to remedy this situation. Is that a fair?
I believe that they have surpassed the civil penalty amount, and they did present a solution that does benefit the consumer directly as opposed to the civil penalty. I agree with all those points. I will say, just in full candor, there is a benefit to the licensee in the fact that they are not receiving formal discipline, which would then have to be reported, on a multi-state index or something like that. So this resolution does provide them the benefit of, hey, we've taken care of the consumer, we acknowledge there may have been a misstep here, do the letter of a warning as opposed to a formal discipline and civil penalty that would need to be reported in other jurisdictions. So there is a benefit to both parties. I just want to make everything
yeah.
fully aware.
Which is part of the motivation on why they're paying more than the $500 going to $742, less their fee, let's be clear about that. It's a good move. So my question is, do we even want to issue a letter of warning?
It is up to you all. It is completely the board's decision. That was the details in our my direct discussions with the licensee was I would at least make that recommendation. It is up to you all to strike that as well. It's completely the board's jurisdiction.
So if we did not issue a letter of warning,
Closed.
and would you notify them in writing that we close the case?
Yeah, the board notifies all interested parties on complaints on the final resolution issued by the board.
Okay. So I'm a little bit on the fence on this, because, I'm just speaking out, because I can certainly see where the agency is benefiting by only getting a letter of warning. On the other hand, there's a part of me that says, do we not want to not reward, but do everything in our power if an agency self-corrects to just say, okay, let's call it good and move on. So maybe somebody outside the industry like Tony might be a little more objective.
I agree. How often does this happen, this situation? This is the first time I've seen it on any of the.
As far as the licensee taking remedial
Yeah.
action to address the issue, this would be the
Clearly,
first
yeah.
time. Yeah, it's the first time I've seen it as the attorney for the board. Granted, I've been here for 14 months,
Never
but yeah.
seen all the cases we've seen. I've never seen it happen, so I agree with Chip on it, that we should maybe not even provide the letter
So
of
just-
warning. because it-
Put your mic on, I'm sorry.
Maybe not provide the letter of warning either, because they did go above and beyond.
And so the board's decision on this complaint would be not to issue the letter of warning, but just go ahead and close the complaint based on the actions and the facts that have taken place.
Yes.
Yeah, I want to make sure you feel okay with it, though. because-
I have no problem with it.
Okay.
It is you all's decision. I am
I know,
advising
I
you.
know.
I think based on the facts, that outcome is justifiable.
I think Roxana, did you have a comment about it?
My only comment to what Tony was saying is it is rare, not only in this program, but in any of programs I have or have had, that we can make the client whole. It just doesn't come up. And
Frankly, I
so-
thought it was a creative proposal by opposing counsel.
Yeah.
Yeah.
And Yeah, I would like to reward them personally and just close it. And, I mean, that's not a vote. That would be my recommendation.
I agree.
So do we need a motion to that effect?
You will, because we're doing just a little bit different from the
Okay.
recommendation that Joe had, so you can do the motion, to just close it and we need a second.
I make a motion on item number 22 that because the collection agency did everything humanly possible to rectify this situation to the benefit of the consumer, that we just close the file, because that is the behavior we are seeking in our industry and our state.
Without a letter of warning or anything. Yeah, clearly. I second.
We have a motion and a second to close case number 22 as read on the record. All those in favor, please say aye.
Aye.
Hearing none opposed, thank you. That, Joe, unless you see anything else that we need, that takes care of our legal report. I have an update that you would give on the rules, but that may be just kind of preparing us for the rulemaking hearing.
Yes, as mentioned earlier, we will be doing a rulemaking hearing based off the notice that we were required to provide through the Secretary of State's office. That'll start at 11. So unfortunately, I have a little time to burn, but we'll go through those rules and do the
Okay.
official rulemaking hearing on the record.
Before we leave the legal report, can I just mention, probably everyone in this room is aware of it, but the Consumer Financial Protection Bureau issued a rule earlier this week that the industry's been on notice that through the notice of rulemaking, and that when the rule takes effect, if the rule takes effect, medical debt will no longer be allowed to be reported to the credit bureaus. That rule was issued, today's Wednesday, Monday, I think it was Monday, but I am aware that there's industry litigation that is going to be filed against the CFPB, and so it'll probably be a fairly lengthy process before the rule actually takes effect. But just making sure that we all understand that it happened.
I'm in the,
I'm actually on the board of ACA, so I've been very involved.
Greg, I'm sorry, can you?
I was just saying, I'm on the board of ACA, the Collectors Association, and have been involved with this litigation that will come out shortly against the CFPB.
So I should probably, for the record, I'm not on the board of ACA, but I have been involved in the ACA case by providing some background information. And I mentioned earlier that I have an ownership interest in a collection agency. One of the plaintiffs in that suit is a partner of mine, a co-plaintiff with the American Collectors Association. So I'm kind of in the middle of it too, and I don't know if that matters in terms of, maybe it's just about Greg disclosing he's a board member at ACA, and I'm disclosing that I've been on the phone as recently as standing outside here a minute ago, trying to help give ACA data for that lawsuit. So,
I mean, at the end of the day, if that rule goes into effect, you wouldn't be able to ignore a complaint where essentially someone had reported if the rule goes into effect, the medical debt would no longer be able to be reported to the consumer report bureaus. The only way I could theoretically see this playing out that would matter is you would have to understand as a board member that information can't be reported to the consumer reporting agencies if the rule goes into effect. If someone were to file a complaint stating that there was an issue with the information reported on their credit report against a licensee, and a licensee had violated the medical reporting rule, you can't just ignore that. We would have to
Right.
take that into effect. But that's the only possible way I could see that coming in. It's not going to affect your position as a board member.
okay.
We just have to honor the rules as passed by the CFPB,
Oh, sure.
the state of Tennessee, or anything else
Sure.
like that.
Yeah, that's great.
Thanks.
I think it's good to just to disclose to you guys that we're not bystanders. We're interested parties. the industry people are.
That makes sense. No, I appreciate the update, and in case, for folks that are watching, that's also a good thing, for them to know that this is out there as a legal case as well.
Super. What's next on the agenda?
Our agenda would be to adjourn now, and then that'll pause both of our meetings, the live stream as well as the recorded Teams. We have a link through Teams to the Secretary of State's rule package, which you all have in paper, that we'll go over. We won't start that until 11 o'clock, so we'll technically take a break. And then at 11 on the dot, we'll go back on the record, both streaming live and through Teams. And then anyone that has questions, wants to participate, anyone that's here, we'll make sure that, everything is answered before. And Joe has, all the pieces for those rules to go.
Are we going to have to go through all those in this public meeting, or just open the floor for questions about any of the rules?
So I have a script. It's not very long. We'll run through that. There are several official notices that I'm required to give, several
Okay.
questions I'm required to answer on the record. I do not read the rules verbatim. I provide a summary of each rule change. I
Okay.
think there's less than 10. It should not take very long. Depending on public comment, if we do get any, that would be the variable.
We're doing it in this room here.
Yes.
Yes, we'll be in this room, and we also have paper copies if someone from the public is here. And then again, the link online that Dana has posted will be available, so.
Okay, so do we formally adjourn this meeting and then reconvene?
Yes, so if
I
I could have a
move.
motion, go right ahead.
Move we adjourn.
A second.
We have a motion by Chip and a second by Tony to adjourn, and I have us adjourning at 10:14 for about 45 minutes. All those in favor, please say aye.
Aye.
Thank you, members. You've got about 45 minutes break. Thank you. Good morning. Today is Wednesday, January the 8th, 2025. My name is Roxana Gamusio. I am the Executive Director with the Tennessee Collection Services Board. This is a rulemaking hearing. I will be turning it over to our attorney here in a second. Before we get started, if I could go ahead and just establish that we've got quorum from our board members. This is a board with 5 members. 3 would need to be here for quorum. Mr. Chip Hellman.
Present?
Thank you. Greg Zworski.
Here.
Thank you. And Tony Zikovich.
Present.
Thank you. We do have quorum. I will be happy to go ahead and turn it over to Joe.
Good morning. This rulemaking hearing is called to order. My name is Joseph Wharton. I serve as an Associate General Counsel in the Department of Commerce and Insurance, Division of Regulatory Boards, and I represent the Tennessee Collection Service Board. Would the board members who are present introduce themselves for the record?
Chip Hellman?
Greg Swirsky.
Tony Zikovich.
And will the Executive Director introduce themselves on the record as well?
Roxana Gamusio.
Thank you. Today is Wednesday, January 8th, 2025. The rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 45204 and Conference Room 1B, Davy Crockett Tower, 500 James Robinson Parkway, Nashville, Tennessee, and also available by electronic means via Microsoft Teams, which can be located on the program's website, www.tn.gov/commerce/regboods/meetings.html. The purpose of this rulemaking hearing is to solicit comments on rule amendments to the rules and regulations of the Tennessee Collection Service Board. The proposed rules amend certain general provisions and rules resulting from the department's review as required by the General Assembly's enactment of Tennessee Code Annotated 45213. Specifically, the proposed rules reorganize the placement of prohibited practices and redefine change of ownership as it applies to limited liability companies and corporations. The proposed rules remove the requirement that the board contact an applicant's character references as part of the investigation to determine an applicant's fitness for licensure. The proposed rules also establish that a violation of 12 CFR Section 1006, Regulation F, is issued by the Bureau of Consumer Financial Protection shall be deemed an unfair or deceptive act or practice in violation of the rules of this chapter. Finally, the proposed rules repeal examinations in connection to licensing. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State. Notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of which time will be the effective date. Please listen carefully. Those members of the public wishing to speak and appearing in person should place their name on the sign-in sheet on the podium to my left. Those members of the public wishing to speak and appearing via Microsoft Teams should put their name in the chat box. Oral comments will only be accepted by those who have written their name on the sign-in sheet and typed their name in the chat box. Is there anyone else that desires to offer oral comments but has not written their name on the sign-in sheet or typed their name in the chat box?
Dana or John, could either of you let us know if there are any comments in the chat box?
We don't have any.
Thank you, sir.
Seeing that there are none, for those attending this hearing in person, I would call your attention to the table behind me. On this table, you will find red-line copies of the rule amendments addressed in today's rulemaking hearing. For those attending on Microsoft Teams, you will find a link in the chat box to the red-line copies of the rule amendments for today's rulemaking hearing. The notice of rulemaking hearing included the entire text of the proposed rules and were published on the Tennessee Administrative Register website on September 27th, 2024. Ms. Gamusio, what additional notice was given to the affected individuals or groups?
Information regarding the time and location of the hearing was placed on the board's website effective October 2nd of 2024, and then also an e-notify was sent to all licensees or anyone signed up to receive notification via the program system on October 1st of 2024.
Thank you. As the board hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. I will now summarize the substance of the proposed rules into the record. Rule 0320-01-.01 Qualification of applicants. Paragraph 1 is amended by deleting subparagraph D. Rule 0320-01-.04, change of ownership. Paragraph 2 is amended by deleting the language an aggregate change of 50% or more and substituting the language any change that results in a different person or entity acquiring an aggregate of 50% or more. Rule 0320-05-.05, false or misleading representations, is amended by adding a new paragraph 2 that enumerates prohibited practices. Rule 0320-05-.10, administrative enforcement, is amended by deleting the text, the rules of this chapter, and substituting the language 12C.F.R. Section 1006, Regulation F, issued by the Bureau of Consumer Financial Protection. Rule 0320-01-.02, examinations, is repealed in its entirety. Rule 0320-02-.02, prohibited practices, is repealed in its entirety. 0320-02-.02, paragraph 1, subparagraphs A, B, C, and E are relocated to 0320-05-.05, paragraph 2. Ms. Gamusio, were any written comments received by the board office for the rule amendments that were not forwarded to me prior to today's hearing?
No.
I will now solicit comments from individuals present at today's meeting, either in person or via Microsoft Teams. Can you ask them to check the chat box one time?
John, again, if you could let us know if there's any comments via the chat box.
There's no comments.
Thank you, Dana.
Next, I will read the names of individuals that have placed, well, I guess we can skip that. Yeah. Seeing that there are none, this now concludes the comment period for this rulemaking package. Lastly, there are several measures that will need to read into the record as required by TCA 4-5-222. All voting will be conducted by roll call. First, I will need a motion to adopt the hearing rule language as amended. If amended, state the amendments on the record. There were no amendments proposed, so as the rules have been presented to you all today, I would need a motion to adopt the hearing rule language.
Motion to accept the hearing rule language.
I second.
I'm sorry, I was not on the microphone. Motion, I make the motion that we adopt the rulemaking.
I second that.
Thank you, members, by roll call vote. Chip Hellman,
Yes.
Greg Zaworski,
Aye.
Tony Zikovich,
Yes.
Joe, all motioned to adopt the rulemaking package. It's approved.
Next, I will read the regulatory flexibility addendum. Pursuant to TCA 4-5-401 through 4-5-404, Prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rule affects small business. The prompt 1, the type or types of small business and an identification and estimate of the number of small businesses subject to the rule being proposed that would bear the cost of or directly benefit from the rule being proposed. These rules may have a minor impact on collection service agencies licensed in Tennessee. There are 671 registered collection service agencies in Tennessee. Of those, approximately 25% are estimated to be small businesses. The projected reporting, record keeping, and other administrative costs required for compliance with the rule being proposed, including the type of professional skills necessary for preparation of the report or record. The board does not anticipate a cost for the administration and enforcement of these rules. Prompt 3, a statement of the probable effect on impacted small businesses and consumers. These rules may have a minor impact on small businesses by clarifying when a limited liability company or corporation must report a change of ownership to the board. Prompt 4, a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the rule being proposed that may exist, and to what extent the alternative means might be less burdensome to small business. The board knows of no other less restrictive or burdensome means than through the promulgation of these rules as amended. Prompt 5, a comparison of the rule being proposed with any federal or state counterparts These rules are comparable to other states' regulations on the collection service industry. The states of North Carolina and Florida regulate the collection service industry. North Carolina requires collection agencies to report any change of ownership in business. Changes of ownership of less than 50% of a business are reported with an ownership change form, and changes of ownership of 50% or more of a business require that the licensee to apply for a new license. In the context of partnerships, corporations, and limited liability companies, Florida requires that consumer collection agencies report any change of ownership of 10% or more. Analysis of the effect of the probable exemption of small businesses from all or any part of the requirements contained in the rule being proposed. Exempting small businesses from the requirements in the proposed rules would not be preferable, since the rules provide clarification regarding a change of ownership, which is required to be reported to the board. Exempting small businesses from the requirements of the proposed rules would reduce consumer protection, because the board would not be able to assess the fitness and qualifications of new owners of small business licensees. I will now need a motion to adopt the regulatory flexibility addendum.
I move we adopt the addendum.
I'll second that.
Thank you. We have a motion by Chip Hellman, a second by Greg Zaworski. By roll call vote, Chip Hellman,
Yes.
Greg Zaworski,
Yes.
and Tony Zikovic.
Yes.
Thank you, Joe. It is accepted.
I will now, I will now read the impact on local government. I will now read the impact on local government statement pursuant to TCA 4-5-228. The Tennessee Collection Service Board foresees no impact on local governments. I will now need a motion to adopt the impact on local government statement.
I move we adopt that statement.
I second.
Thank you. We have a motion by Chip Hellman and a second by Tony Zikovic to adopt the local, the impact on local government statement. All those in favor, I apologize. By roll call vote, Chip Hellman,
Yes.
Greg Zaworski,
Yes.
and Tony Zikovic.
Yes.
Thank you.
I will now read the answers to the questions required by the Joint Government Operations Committee. All agencies, upon filing a rule, must also submit the following pursuant to TCA 4-5-226I1. A brief summary of the rule and a description of all relevant changes in previous regulations effectuated by such rule. The proposed rules amend certain general provisions and rules resulting from the department's review as required by the General Assembly's enactment of 10 Code Annotated 4-5213. Specifically, the proposed rules reorganize the placement of prohibited practices and redefine change of ownership as it applies to limited liability companies and corporations. The proposed rules remove the requirement that the board contact an applicant's character references as part of the investigation to determine an applicant's fitness for licensure. The proposed rules also establish that a violation of 12C.F.R, Section 106, Regulation F, issued by the Bureau of Consumer Financial Protection, shall be deemed an unfair or deceptive act or practice in violation of the rules of this chapter. Finally, the proposed rules repeal examinations in connection to licensing. B, a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. These rules are in response to the General Assembly's enactment of 10 Code Annotated 4-5-213. Tennessee Code Annotated 4-5-213 requires that by December 1st, 2023, and every 8 years thereafter, a department with rules promulgated and published on the Secretary of State's website pursuant to 10 Code Annotated 4-5220 shall submit a report regarding the department's chapters in effect as of July 1 of the year that the report is due to the chair of the Government Operations Committee of the Senate and the chair of the Government Operations Committee of the House of Representatives. The report must include a determination of whether each rule in the chapter should be amended, repealed, reviewed further, or continue in effect without amendment. C, identification of persons, organizations, corporations, or government entities most directly affected by this rule, and whether those persons, organizations, corporations, or government entities urge adoption or rejection of this rule. These rules affect current and future board licensees who are owned by limited liability companies or corporations. The proponents of these rules include industry stakeholders and members of the collection service industry who believe these rules will clarify the meaning of change of ownership as it applies to limited liability companies and corporations. D, identification of any opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. There are no known opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. E, an estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state that the fiscal impact is minimal if fiscal impact is more than 2% of the agency's annual budget or $500,000, which is ever less. There is no foreseeable probable increase or decrease in state and local government revenues and expenditures. F, identification of the appropriate agency representative or representatives possessing substantial knowledge and understanding of the rule. Joseph Wharton, Associate General Counsel for the Tennessee Collection Service Board, and Roxana Gumucio, Executive Director for the Tennessee Collection Service Board. G, identification of the appropriate agency representative or representatives who will explain the rule at a scheduled meeting with the committees. Joseph Wharton and Roxana Gumucio. Office address, telephone number, and email address of the agency representative or representatives who will explain the rule at a scheduled meeting of the committees. The contact information for Joseph Wharton and Roxana Gumucio are listed. I, any additional information relevant to the rule proposed for continuation that the committee requests, not applicable. I will now need a motion to adopt the additional information for the Joint Government Operations Committee.
I move that we accept the additional information and answers to questions for the Joint Government Operations Committee.
I second.
Thank you. We have a motion by Chip Hellman and a second by Tony Zikovich to accept all of the responses for the additional information to the Joint Government Operations Committee. By roll call vote, Chip Hellman,
Yes.
Greg Zaworski.
Yes.
Tony Zikovich.
Yes.
Joe, this is in agreement.
Goodness. This concludes the rulemaking hearing. Following this hearing, the rules will be, number one, held for additional comment and/or rerouted if substantive changes, but if not, then put on a rulemaking form, Secretary of State 7039, submitted to the Governor's Office for final review, and then submitted to the Attorney General's Office for review and approval. Once Attorney General's signature is obtained, these are filed with the Secretary of State and generally become effective 90 days from the date of filing after receiving a positive recommendation from the Joint Government Operations Committee. Thank you for being here today.
Thank you, members. I just want to make sure, John or Dana, has anybody added anything through the chat or any other items that we might need to address?
No.
Thank you. Thank you, Joe. I have nothing else.
That's all I have. Thank you so much, board members.
Yep. Thank you. Good job, Joe.
Sorry.